Beneficiary involvement in trust direction. So again, we're covering the directives that your trust must have. Okay, this one is the beneficiary involvement and trust direction. So your trust must explain what powers your beneficiaries have and what involvement they have in the trust affairs. Can they vote on agendas? Can they vote for trustees? Can they vote for when their distributions are made? If the trust is a statutory trust, more often than not, your state laws will dictate that. If it is revocable, they can be involved with no problem, and most likely, again, the state laws will dictate that. If the trust is irrevocable, any beneficiary control opens the trust up to be deemed a partnership. Okay, we went over that earlier. Too much involvement by beneficiaries will make the trust look like a partnership. Certificate issuance. How the TCUs, the Trust Capital Units, or UBIs, Units of Beneficial Interest, will be handled. The Trust Protector. Now, if your trust is revocable, it will not have a trust protector. There's really no need for it because the trust protector's main job is to watch over the trustees, and if your trust is revocable, the grantor can do that. The grantor has the power over the trustees. But if you do have a protector, you're going to have bylaws for the protector. The protector is going to have duties and responsibilities that are going to need to be outlined as well. So the basic description of protector and the basic duty is to watch over the management of the trust. They are more powerful than the trustee and work for the interest of the beneficiaries, but primarily are concerned with making sure the grantor's directions are followed. They are only answerable to the grantor. Power of attorney. Who will represent the trust in the event of court action? So your trust must list who represents the trust in the event that there's a claim against your trust. Trust duration. This covers the rule against perpetuities. It's usually 21 years after the death of the last eligible beneficiary or according to state law. Sometimes the state law will dictate how long your trust can last. Termination of trust. So your trust must discuss who can terminate the trust, under what conditions, and what happens to the assets once the trust is terminated. Your trust must cover its governing laws, the situs of the trust, where it's domiciled, what laws dictate it, what jurisdiction. Your trust must have severability. Okay, this is a contract rule as well. And it's a statement that should any part of the trust be deemed void, other sections cannot be arbitrarily deemed void as well. This protects the trust from being invalidated based on one mistake. Severability is basically if your trust has 100 provisions in it, 100 rules, and 2 of the rules are through court action or through some sort of authoritative arbitration ruled, 2 of the provisions are ruled to be void or mistakes. Okay, they cannot then say, well, because these 2 rules out of 100 are void or non-applicable, we will nullify the whole trust. Okay, that's in contract law as well. You'll see contracts with laws or with a severability clause that state that the contract cannot be voided based on one rule or one mistake. Okay, or one invalidation of one particular section of the contract. Protections. So your trust should have a no contest clause, privacy oaths. Now, privacy oaths are not necessarily needed for a revocable trust because the grantor has ultimate control. Well, I guess a revocable trust can have a privacy oath, but Since the grantor has all rulership, the information that's disseminated to the beneficiaries and trustees are strictly at the grantor's discretion. Whereas an irrevocable trust, the trustee is an intermediate between the beneficiaries and the grantor in most cases. And sometimes the grantor will deal with the beneficiaries without the trustee. So there may not be an hierarchy in terms of what information is disseminated, or there may not be a monitor on what information is disseminated. But with privacy oaths, everyone receives the oaths and everyone is brought in synchronicity with what must be kept private and what can be disclosed. Okay, so from that explanation, you can deem whether an irrevocable trust or a revocable trust would most need a privacy oath. All of them need, though, a no contest clause. And what this is that should anyone challenge the trust, okay, there's a penalty. Now, the penalty can be a fine, the penalty can be a withholding of distribution, the penalty can be dismissal. But all trusts, whether revocable or irrevocable, need a no contest clause. This is a disciplinary clause. Definition, very important. This is where you can put the definitions to your words into your document so no court can determine their meaning. This is really only important for an irrevocable private trust. Any revocable trust, any public trust, the court's going to have administrative power over it, as we discussed earlier, because it is a United States associated entity, and so it really doesn't matter what you define in your trust. I'm pretty sure there are conditions under which it can give you some leverage, but if the courts have ultimate control, I don't really see how definitions are needed. However, to the contrary, an irrevocable private trust definitely can use this particular power, and this is the power to define the meaning of your very words in your trust. So say for instance you want a trustee to automatically represent board of trustees, so you put in your definitions trustee, and then you put slash means board of trustees, means individual trustee, means more than one trustee. Whenever that word is used in your trust, then it means either of those things. And if the trust should go to court, if it's private, they have to construe any particular part or any particular event that has that definition as meaning those words. So when they come across the word trustee, they cannot say, well, this means trustee according to us. Your trust is its own law. Okay, a jurat. So this is, of course, once you notarize your trust, you're going to need a notary jurat. Okay. Incidental requirements, meaning that these are not necessary, but are good to have. Okay. 2 trustees at least, one for appointment, another for succession. Okay. And if the one who is up for succession or who is listed for succession, they can be a co-trustee so they can, it's basically like on the job training. Okay. Another incidental, which is not necessarily incidental if you're married. Okay, if you're married and you don't have a trust and you decide to set up one, you cannot set up a trust and start transferring property into it without telling your spouse. Okay, a lot of people miss that. I see a lot of people formulating trusts or being advised on trusts and they're not told this. I don't get that, because marriage is a business. All right. So now we're about to go into the trust templates, so to speak. Okay. I don't like to call them templates because I don't suggest you use them word for word. Again, they're basically outlined to give you the general idea of what should be contained in each article. Okay. The verbiage that you should use for each point that these sentences or the paragraphs make. Now, of course, you can use some of the verbiage, and you can use a lot of the verbiage. But at some point, of course, you're going to have to adjust it for your trust's own particular needs. All right. So the trust models you're about to receive are trust instruments by which you can choose the public or private version of trust administration. Trust Model 1 is a public grantor's trust. You should try not to copy it verbatim. Instead, use the verbiage as a guideline for your own expression of trust. So again, it's a guideline. It is purposely not a fill-in form so that you must copy and paste the text line by line in order to ingrain it into your memory. The same applies to Trust Model 2. On both models, the bracketed blue text are notes, not verbiage to be copied. So when you see, as we go through these models, then the first one we go through, it will be the public trust. Okay, that will be this one. Okay, Trust Model 1 statutory. Okay, so we're basically going to go through a trust and go through the verbiage and learn what we've just learned, the definitions of what we've just defined and what we've just covered in terms of the components that need to make up the trust. Okay. Trust Model 2 on both models. Oh, excuse me. It is purposely not a fill-in form so that you must copy and paste the text line by line in the order written to better ingrain it into your memory. The same applies to Trust Model 2. On both models, the bracketed blue text are notes, not verbiage to be copied. Okay, I went over that. Trust Model 2 is an irrevocable trust with private administration verbiage. Okay, so that will be this model. Okay, this will be our Trust Model 2. Trust Model 2 is an irrevocable trust with private administration verbiage. Even though I give you both modes, I strongly suggest you build your first trust around the public model until you become adept at the trust science. Trust is a serious matter. If that has not been made clear by now, by showing you the people who basically control the planet using trust law, and also the spiritual aspects of trust that I showed you the excerpts of. It is used in courts, politics, law, and real estate. That is why the courts can take anything away from you. All areas of your life are put into the hands of the state or federal government who act as your trustee, whether you know it or not, done by contracts, marriage license, driver's license, any other license you get. That's a contract. You have signed without knowing or your implied consent. Remember, the format of the titles and headings in this are in order that you can use to form your trust. But other than the titles, you should use your own words from reference of the trust verbiage given. This is better for your learning. Trust me.